Mic check, 1 2 1 2. Hello all. Let me increase this microphone volume. All right. With the excitement over, welcome to Skills. This is Nate Brody, and today we are going to be going over the multiple choice midterm for family law. So there were 16 questions, and with these 16 questions, the class did actually really well. The average score was a 26. So out of a possible 33 points, 26 is pretty good. And I think the top score was at 33. So I wanted to start with, let's just jump right into it. We'll go over all 16 questions. If anyone has a question, they can put it in the chat if you're watching online. Other than that, you can also email me or speak to me afterwards. We have some people in the class. If a question is asked, I'll repeat the question so you guys online can hear it, and we will get into it. So the first thing I want to do is turn down the lights in the room so I can see. Turned them off, but I think we're still good. All right, so again, this is Nate Brody, and let me just open up the chat so I can see if anybody is asking any questions in the chat. All right, so we got 5 people watching. All right, so let's jump right into it. Where is the mouse? Okay, so question 1. Elizabeth and Sonia decided to live together and form a family. And that's great. They enter into a written contract that Elizabeth will give up her legal career to be a full-time homemaker in exchange for financial support from Sonia for the rest of her life. So they have a written contract that one is going to give up a legal career to become a full-time homemaker, and the other in exchange for financial support. They split up several years later, and Elizabeth sues Sonia for the maintenance payments. So Elizabeth will most likely. So here we have 4 answers, and here we'll start because myself and the professor went over this particular question and deemed 2 answers to be correct, because the call of the question didn't ask for the best answer, and we thought it may have confused some students. So let's go over each one of the answer choices. Answer choice A, successful because each understood and voluntarily signed the agreement. So this answer was a correct answer choice. And so was answer choice B, successful if she can establish that the agreement was not based solely on provisions of sexual services. Now, remember in the outline when you have contractual agreements for non-married couples, how they could be enforced, and A and B outlined some of the prohibitions. One, that it couldn't be. The test that we learned from the outline was really encompassed in A and B. So if you chose either A and B, these were both correct answer choices. C is incorrect because it says successful if the pair held themselves out as married, but we know that common law marriage, there are 4 elements. This is only one of the 4, so that wouldn't work. And the D is unsuccessful because maintenance is requires a valid marriage. No, not unless you have a valid contract, then you would also be able to get maintenance. So for answer choice A, for question 1, the answer is either A or B. If you chose either A or B, you would have gotten credit. Does anybody in the crowd have a question? No? All right, so we're moving on to question 2. And there's no questions in the chat. So question 2 from the family law midterm is Wanda marries Will in 1989. She leaves him in 1995 and goes to live with Harry. So she's married, and now she's living with this other guy, Harry. So Wanda and Henry hold themselves out to be husband and wife to all their family and friends. That's great, but that doesn't mean anything because what? She's already married. So they can do whatever. But she must get a divorce if this second marriage or relationship is to be deemed, legal, or it would be recognized as being married. Because right now we have bigamy. In 2010, after Henry's death, due to a botched brake job in his car, he's going to get some money, Wanda sues the mechanic. So then the mechanic challenges Wanda's status as Henry's wife. So if that is true, if the mechanic's challenging whether Wanda is Henry's wife, that is going off the fact that he believes that Wanda's marriage to Henry was bigamous, in the sense of that she was already married and she hadn't gotten a divorce, so the second marriage would be void. And that's the rules that we learned. You can only be married to one person at a time, and if you are married to two people, then the second marriage is the one that never existed. It is void. So let's evaluate the answer choices. First, let's go to the call of the question. What is Wanda's best evidence that she had a valid marriage to Henry? So the question is asking her, okay, so how can she prove that her marriage was valid? So first, so we know, before we even go to the answer choices, that she has to prove that in some way she either got divorced or that first marriage was void in some way. Otherwise than that, then she's out of luck. She can't be married to Henry. So let's look. A, she thought that Will divorced her years ago. Well, that's not a great answer because thinking that Will divorced her is a lot different than actually being divorced. So just because she thought that doesn't mean anything. That means her marriage to Henry would be actually void because she would still legally be married to Will. Answer choice B. Will was her first cousin, and their marriage violated state incest laws. Now, this is a little tricky because if that statement is true, in New York, for instance, first cousins can marry. But if you have another state that bars first cousins from marrying as incest, then that would make that first marriage void. So I like answer choice B. Let's look at answer choice C. Will died in 2000. Well, if he died in 2000, let's say Will died in 2000. That would have ended her quote-unquote marriage with Will. So she left him in 1995. 2000 he died. And in 2010, he had the brake job where he dies. So this is a possible answer. But now it kind of is really determinative on when this second marriage even happened. Did it happen before 2000? Did it happen after 2000? Did this common law scenario happen? It happened in 1995, but did it happen after 2000? So there's a lot more questions that we have to answer if C is the correct answer. But C would make it, but we would have to know that Wanda and Henry's common law marriage or any type of marriage would have had to happen after Will's death. And then D, Will fraudulently deceived her into marriage. But again, that makes the marriage voidable, not void. And you'd have to go to court and ask a court to dissolve the marriage if it's voidable. And without facts to say that it actually did happen, D wouldn't work. So the correct answer here would be B. And B, the majority of students got it right, saying that, again, this is the best answer if it violated incest laws. So hopefully everybody got that question. So 2, the correct answer is B. Moving on to question 3. All right, in question 3, a couple begins to live together after college. The two hold themselves out in public as husband and wife, although they never formally marry. Okay, so they're holding themselves out. They never formally marry. There is some evidence that they consider themselves to be married. Okay. The man promises to give his wife a mountain cabin that he inherited years before from his father if she doesn't go back to school, but instead supports him financially and keeping house while he works really hard. She complies with the agreement. So here we have an express agreement. I'll do X, you do Y, and we're good. And it doesn't seem like there's any sex, or this contract is based on sex, so we don't really have to have that to worry about. Ultimately, the two break up. Oh no! And the woman consults you. She realizes she really wants the cabin that he promised her. In order to get the mountain cabin, what would be best off to? Oh, you would be best off to. I don't know why I'm reading that so poorly. It's like a weird sentence, right? So I don't know. It's like, yeah. But anyway, so we want this cabin. Generally, the agreement was I do X, you do Y, and if I can fulfill if I fulfill this criteria, I get a cabin. She fulfilled the criteria. Now she wants the cabin. So it seems like the easiest way for us to do this is just go to court, right? We have a contract. We had the agreement. I fulfilled my part. Now he has to give me the cabin, right? That's the easiest way we can go through this. But let's say if we were married. Let's say if they were married and she now wants the cabin. Well, there's a couple of problems with that. And this is one of the problems I have with this question, is that one of the issues with this question is the fact that, let's say they got a divorce. And this is something that the class didn't know. That's why I think this question may have been a little bit, it may have been a little too much. But if you get divorced, then things that you get through inheritance aren't part of the marital property that is available for distribution. Now, that's something that wasn't taught to you, but that's something that generally happens within the state, especially in New York. So the fact that he was bequeathed this through a will or a process of someone dying, that kind of takes it out of the realm of property that could be given to someone, or that could be distributed through this marital property piece. But you guys don't know this. So let's say, for instance, they did get a divorce. You have a lot to go through. Now you have divorce, they have to chop up who gets what, that type of thing. So it's a longer process, and it's a lot harder to also even argue if you're this person's lawyer, that she wants the cabin, they've been married so long. The easiest argument that you're going to have is just a contractual one. He said X, I did X. He said he'll give me Y if I do X. We have a contract. So the best answer, the best way I think this person can get this cabin is just simply arguing that we had a contract. So let's look at the answer choices. A, asserted claim for common law marriage. Well, do we have all the, are there even all the common law marriage elements there? Do we have all four? We have them holding themselves up to be married. We have them cohabitating. Do we have intent to be married? We had them saying, there's some evidence they consider themselves to be married, but I don't see really an intent element here. So it seems a little problematic. Assuming that the state allows it and seek the cabin and equitable distribution proceedings. I don't know. I think it's a little convoluted, but it's possible. Let's see if there's a better answer. B, assert a claim as an unmarried cohabitant for breach of an express contract. As we said before, that seems simple enough, right? We have an express contract, and I want what I was promised because I held up my end of the bargain. B, to me, sounds like the best answer. Let's see. C, assert a claim based on marital division of property. Again, I don't think that's going to work, and for the reasons why I said before. And D, assert a claim based on breach of implied contract, but I don't think you have an implied contract here. You have an express contract. You do X, I'll give you Y. So the correct answer here is B. I want to know if anybody has any questions. Again, if you have some questions for the people who are watching at this time, just please put them in the chat. And we're going to be moving on to question 4. So question 4. All right. The last question, just so everyone knows, about 60% of the students got that one correct. Question 4. Now this is where there seemed to be a little. Now the first thing, because last year when I was going over the property quiz with the same professor, there was a question where everybody was waiting for me to go over, and it was like the blow up question. Because as soon as we went over the question, it was like a whole bunch of questions. So question 4, I think, is one of those questions. So the first thing I want to tell you, question 4 has no right answer. It has 2 close to right answers, but it actually, all the answers are technically not, I would say, not correct. But there are 2 that are just way off, and there are 2 that we accepted. So let's go through the question, and I'll explain why we chose the 2 answer choices that we did to give students credit. And I'll say this: the majority of students, the high majority of students, got credit for this question. So a few days after Oscar and Anna celebrated their 13th wedding anniversary, 13 years, Anna was killed in a car crash. Boy, these could, they got to get some better mechanics or something. We got 2 car crashes and 2 questions in a row. Tim now claims that he was married to Anna before they met Oscar. So Tim saying, I'm married to Anna before she even met Oscar. So we're talking about 14, 15 years ago, whenever they met. So they're asking us, what is Oscar's best argument for inheriting Anna's estate? So if Oscar is coming forward and saying, hey, I want to inherit her estate, he has to prove either that her and Tim were never married, or that even if they were, that marriage was either void or annulled in some way, or something happened where that marriage was legally declared null and void. Answer choice A. Oscar was Anna's common law spouse. So does A work? Well, A doesn't work. Because let's say if that's true, Oscar and Anna were common law spouses. Well, if Tim was married to her before that, then they could never be common law spouses, because that would make Oscar a second husband to Anna. So that would make that common law marriage void. So that wouldn't help Oscar. That would actually hurt Oscar's argument. So that's why A is incorrect. A is just functionally incorrect. What about B? If Oscar can say Anna's marriage to Tim was void because she was a minor when the ceremony took place. Now, based off the rules that we heard in class, that's a wrong answer choice. Why? Because age makes the marriage voidable, not void. So, if this is correct, Anna would have had to go while she was a minor at that point. Right? Tim would have to go while he was a minor and go to the court and ask the court to annul the marriage, making it voidable. So since that didn't happen, or we don't have any facts to say that happened, then this answer choice would be incorrect, because she would still have been married to Tim, even if he was underage when they got married, because it's not void, but voidable. What about C? Anna's functional marriage to Oscar effectuated a common law divorce with Tim. That's just junk. Common law divorce. If you're a common law marriage, you'd have to go through the process of getting an actual divorce, going to the court, asking them for a decree saying that you were divorced. So C, there is no common law divorce doesn't happen. C is just wrong based on the law. So we know A and C are just obviously wrong, and we know B is wrong. So now what about D? Anna's marriage to Tim was invalid because Anna and Tim never obtained a marriage license. Now again, in New York, under the rules that we learned, obtaining a marriage license doesn't make your marriage no good. Remember, we read the case where they didn't obtain a marriage license, but they went and got solemnized and went in front of the judge and said, we want to be married. And the court said, hey, just because you didn't get a marriage license doesn't mean your marriage is no good. The fact that you went through the process, you have a valid marriage. So even though B and D, we chose to give answers to anybody who chose B and anyone who chose D. And that's just because A and C were just totally wrong. There could be some instances where some states, for instance, if the person is 2 years old, where that marriage would be void on its face. And there are some states who may hold that marriage licenses are fatal to marriages. But in that case, we said B and D would be the best answers in this scenario. A and C are just 100% wrong. But we can understand how people can have arguments for B or D. So if you chose either B or D, you got credit for this answer. But I will say this was a bad question. And B and D, if you chose either B or D, you got credit for it. So for answers for question 4, B or D was an acceptable answer choice. Any questions? All right, we're moving on to question 5. So this is Jonathan and Elisa. Both 16 get married without the knowledge of their parents. In their state, parental consent is required for all children under 18. They're 16. They need their parents' consent. A month later, Elsa was killed in a skiing accident. Jonathan claims the remains of Elsa's estate as a surviving spouse. Elsa's mother, Dorothy, moves to have the marriage declared invalid. So they're still 16 because this is a month later. Now Dorothy's asking for the marriage to be declared invalid. So what do we know about minor marriages? They're voidable. So one of the minors would have to go to in front of the judge, the same process. What else do we know? Well, we know that she's now dead, so he is a surviving spouse. And the only way that the mom seemingly can win is that if she can prove some way this marriage was void, not voidable. Because the person who would actually have to go and get it void to make it to ask the court to make it void is dead. So that seems to foreclose that option. Now, Jonathan, let's evaluate the answer choices. It says the court will find 4. So this is question 5. So let me say my answer sheet to make sure I'm right. Okay. So A, Jonathan, if he can show that the marriage between minors is void and not voidable, that is a good answer choice. But again, under what we've learned in class, we learned that marriages between minors is voidable, not void. So I'm going to hold that answer in abeyance and say that is not the correct answer, because under what we've learned, minor marriages are voidable, not void. What about B? Jonathan, if he can show that his parents consented, again, that doesn't resolve the issue. Even if his parents, then we'll still have to talk about Elsa's parents or Elisa's parents, because again, she's under that age restriction too. So if that's true for Jonathan, it would also have to be true for Elisa. What about finding for Dorothy if she could show that Jonathan was legally married to someone else when he met Elsa? Boom. Well, then that makes their marriage done, right? If he was married before, and she can show that he was married to someone else before they met, then that would void his marriage to Elsa, giving her the win. And what about D? If she could show that Jonathan fraudulently induced Elsa into marriage, well, D again is voidable. So you would then need Elsa to go to court and say that this marriage is voidable, and the judge to go through it. So the only way that this marriage between Jonathan and Elsa would be automatically void would be C. If you can show that Jonathan was legally married to someone else at the time, and C is the answer choice for question number 5. And the majority of students picked C as their answer choice. If you have any questions, just let me know. Question 6. Amanda and John have been living together for 10 years. During that time, John bought a house in which they lived. John worked outside the home while Amanda took care of the home, handling all of the cooking, cleaning, and laundry. She also took care of John's children from a prior relationship. This is like, I need to marry her. What's her name again? Amanda and John filed joint tax returns with the local, state, and federal governments. Amanda told all of her co-workers, friends, neighbors that she and John were actually married. Likewise, John introduced Amanda to others as his wife. When they moved in together, Jonathan told Amanda that he loved her as much as any person he could love another, and he promised that he would always take care of her and would share his earnings with her equally for the rest of their lives. He further explained that he did not want to marry her because he had seen so many marriages fail. Uh-oh, that is a big red flag. What are we missing at this point? It seems like we are missing one critical piece, and that critical piece is the intent to be married, because he's saying here that he didn't want to get married because he's seen so many marriages fail. Next, he says after 10 years together, so they've been together 10 years, the couple splits up. Amanda sues John on two theories. First, she claimed that the couple had a common law marriage and that she's entitled to alimony and equitable distribution of marital assets. Second, she sought to enforce the contract between them. Okay. So we have two claims. One, she common law marriage, and the second is that they had a contract. So let's take them in one by one. We'll first look at the common law piece. I think the common law marriage is definitely out because he had no intent to be married. It says it pretty clearly. He didn't want to get married because, and his reasons was that he saw them all go bad. So that intent to be married piece, it seems to be fatal to this particular question. So intent to be married is done. So I think he doesn't have any common law reasons. The second piece of it is that we do have some language here for think of pretty much either express or implied contract. If you he loved much, love another person, take care, shares earnings. But what is she supposed to do in return? It doesn't really say. It doesn't really say they have a contract, right? But they may have an applied contract where if you do all this, let me see, John worked inside the home, she took care of all. So she's taking care of all this stuff. He says, I'm going to take care of you for the rest of their life. She takes care of the kids. So you can make an argument for an implied contract, right? The fact that she's doing all this stuff, he's saying, I'm going to take care of you for the rest of your life. You have an implied contract scenario going on here. So we're looking for something that does two things. Let me just make this bigger so everybody can see these questions a little clearer. Sorry guys, I just want to make this a little bigger on the live stream. Okay, so here it seems like we are going, let's evaluate these answer choices. Go back here. All right, so in a jurisdiction that recognizes common law marriages, which statement is most accurately describes the viability of Amanda's suit? So, A, she may be able to recover against John on either common law. I don't like that at all because we've already decided common law is out because he didn't have the intent to get married. The question more or less says that. A is out. Let's look at B. Amanda may be able to recover against John through contract claims, but will not be able to establish a common law marriage because John's lack of intent to marry. That's exactly what we predicted. I think B looks phenomenal. What about C? Amanda is likely to establish the existence of a common law marriage. No, again, no intent to be married. Full stop. Why even read the rest of this? And D, Amanda is likely to lose on both common law marriage and contractual theory as well. No, because, again, the contractual theory, we do have an implied contract. She was doing all this stuff. She was promising all this stuff. You do have an implied contract, seems like here. So it doesn't. So it's not really, I can't say by 100% she'll lose. It's possible, but I think B is just the better answer because we know she can't establish a common law marriage, and we know that the contractual claims, she may be able to recover from the contractual claims. So for this question, the answer choice is B. And this is question 6. If there are no questions, let's move on to question 7. Let me just make sure this is. All right, hold on. I have a couple of questions here. Let me see. All right, a question for question 5. Regarding the minors, isn't only the minor parties to the action allowed to go to court? Why is the mother allowed? Well, that's true, and that was one of the issues that we came forward to. And also, don't forget, the person was dead in question 5, I believe, right? Wasn't the mother dead in that question? Wasn't the child dead in that question? Let me go back to question 5, because that was the question. Yeah, because the child was dead. So you're right, the mother wouldn't actually be able to go to court, but in this particular instance, the minor is dead. So I agree with that. But again, I don't think that was indicative to this question. For question 5, we're going to minus. Yes, all right. Also, go back to question 3 and explain why was D wrong. Okay, I'll take a quick step back to question 3. And D was assert claim for breach of an implied contract. Well, wasn't this is the college evidence they'd been married, promise. Oh, because we have an express contract here. Some evidence, because the man promises to give the woman a mountain cabin that he'd inherited before the father if he didn't go back to college, but instead supports him financially. Yes, so this is an express contract here. I'll give you the cabin if you do A, B, and C, and she complies with the agreement. So that's not an implied contract. It seems to be an express contract. Because it literally states the terms. If you do X, I'll do Y. Going on to question 7. If you have any other questions, let me know. Was it question? Yeah, we just did question 6. All right, question 7. Sorry, I'm just having a little technical issue here, but we're making it happen. All right. So right now we're at question number 6. I'm sorry, we're at question 7. So, question 7 we have a New Yorker. We have Alice in New Yorker. Okay. So this question, this is one of the few questions where everybody got it right. So this was 100%. This must have been just like the easiest question on the planet, because we have 100%. No one got this question wrong. Appellant Alice lived in a New York City home with her son and her 2 grandchildren. Okay, great. The 2 grandsons were first cousins rather than brothers. One of the grandsons moved in with the appellant after his mother's death. Alice received notice that she was in violation of New York City criminal statute that limits occupants of a dwelling to members of a single family, not extended family members. So we can't live with extended family members, only immediate families. The appellant's family did not meet the definition required for a single family because they had extended family members there, and she was convicted and sentenced to 5 days in jail and a $25 fine. She appeals her conviction, claiming that the statute is unconstitutional. What is the court likely to hold? So this is obviously Moore versus City of Cleveland. The grandmother, she can live with people in her household who are relatives. She has nothing but relatives in this house. So this would be held unconstitutional because you have the fundamental right to live with relatives based on Moore versus City of Cleveland. So let's look at the answer choices and see if we have anything that says unconstitutional. So we can just take out C and D as constitutional because obviously that would violate the Moore versus City of Cleveland. Let's look at A. The statute is unconstitutional because Alice has the right to live as a family unit with relatives. Check that box. That seems to be correct. This B, the statute is unconstitutional because the state has a bare desire to harm an unpopular group. Nothing in the facts will suggest that. It seems like A is the proper answer here because this question is literally seems like the facts and the holding of Moore versus City of Cleveland. So, for question 7, A is the correct choice. Moving on to question 8. Again, if there's any questions in the live chat, I will be going over them. Just let me know. Okay. Question 8. Sarah and Mark come to you. Why are they coming to me? And they tell you, or me, that the 2 days before, on a lark, while they had a group of friends were in Las Vegas, they stopped by a wedding chapel and were married by an Elvis impersonator. Thank you. Thank you very much. They tell you that they only did it because they were drunk at the time. Okay, we're drunk. And they never got a license before going to the chapel. So, hey, we never got a license and we were drunk. They thought the ceremony was part of a karaoke performance happening on stage. That is one hell of a karaoke performance where they say, do you hold yourself? A lot of people could be probably fooled. So, what's your best advice to them? So, question 8 is one of those questions where since it didn't ask for the best answer choice, two of these answer choices seem very, very, very good. So, let's go through the answer choices. Well, first, let's go through answer choice A. They need to seek a divorce. That seems like a very good answer. You went through the ceremony, you got married. Now, even though, for instance, in the rules that we've learned, the marriage license, even though it's a requirement, it's not fatal to a marriage. So if you've gone through the ceremony, said you were doing, or were married by an Elvis impersonator, then it seems like you're married and you would have to seek a divorce. So that A, I think, is a good answer choice if you're giving them advice. Now let's look at B. They should get an annulment based on lack of intent. Well, that also seems like a good choice too. Lack of intent to get married, you can go and say that you didn't have this requisite intent to get married and make that argument. So A and B would be pretty decent answer choices for this question. And because of that reason, anybody who chose either answer choice A or B, which was, I think, 90% of the class, got credit for this answer choice. So now let's look at C. They were not lawfully married if they did not have a license. Well, that's not true. Remember, we read the case that stated that, remember the case in which the person didn't get the marriage license, but they went through the ceremony and the marriage was still good. So C is no good. And D, since they did not live in Nevada, the marriage is not valid. No, because, just functionally millions, thousands or maybe even millions of people have gone to Las Vegas just to get married. And people go to Mexico to get married. That doesn't mean your marriage is not valid because you don't live there. So C and D are obviously wrong answers. So A and B seem like the best of two answers. So A or B is correct. Again, if you have any questions for those who are watching in the live chat, just put your questions there. I will try to answer them. And anybody in the room who wants to make a question, please just shout it out. Moving on to question 9. Oops. All right, question 9. So, now we had some arguments with question 9, but I lost the argument. So, which of the following is not a formal requirement of marriage? So there were two that we obviously know. We know A, license, and C, solemnization. We know those are two requirements for marriage. So now it's between registration and cohabitation. B, cohabitation, D, registration. So I've been married for a while, and I know registration is a formal requirement, but I wasn't too sure if you guys had realized that, but the professor was very clear that she had mentioned it multiple times in class. So, for this question, the only correct answer choice that was accepted was B, cohabitation, because again, it's not a formal requirement of marriage; it's a formal requirement of it's an element of common law marriage, and not a formal requirement of marriage. So, B here would be the correct choice. And I think, let me look to see how many people got this one right. Like 90, what is it? It's like 95% of the people got it right. So a high majority of people got this one right. So the correct answer choice here was B. Yes. So we got a question in the chat. So either A or B got credit. So what was intended to be the correct answer for number 8? Number 8, the intended correct answer was supposed to be B, but it turned out was supposed to be B, but A or B was actually credit was given for either A or B. There's another question. Well, this is really just a statement. Yes, that's correct. So there was another statement that was put in the live chat, but I'm just going to move on to the next question because we're running out of time. And thanks, Gail. So question 10. So we have 6 more questions. I'm starting to get separation anxiety because this thing is going too fast. So we have another 10, 15 minutes before this room is. I've booked the room for about an hour. I'm probably going to have to book it longer some more time. So this is the home stretch. We got 6 more questions, and we're at question 10. Now, just for a quick intermission, remember, skills every week is going to be here. 2 o'clock on Sundays, live stream, just like this. So next week we're going to be delving into evidence and constructs. One thing about constructs we're going to be delving into is I'm going to start giving you some of the rules for constructs because it's starting to get, going through the class notes and class structure, a lot of students have been coming up to me with questions about the rules and how the rules should look. So I'm going to be giving you hard rules for constructs so you guys can see what the rules should look like, and then we'll use the cases to kind of illustrate those rules. So for constructs, you're going to be getting that. Also, I've been looking for my personal constructs outline that I prepare every year. There's one that I've been trying to figure out, but that's the one I'm looking for. So I'm going to massage. If you guys want to send me your constructs outlines or even your evidence outlines, I'll definitely take a look at them to see, how they look. And I'll be putting up a couple of just skeleton outlines so you guys can maybe even use those going forward for constructs. Now for evidence, there are some other videos that I'm going to be putting up, especially about character evidence and so forth, so you guys can see just some different viewpoints on how character evidence is. There are a couple that are up on the site now for 404 and 405, and I'm going to be releasing last year's evidence material from Valentine's class, from the skills portion, for hearsay and all that other stuff, because she's more or less teaching the same thing. And it's funny because I think the same issues that we had last year are coming up again this year too. So you'll be seeing that stuff being released pretty soon, maybe in the next couple of days. But now let's transition back to question 10 for family law. Okay, question 10. After Travis and Daryl got engaged, oh, that's great, Travis had his attorney draft a prenuptial agreement. Okay, so we're at prenuptial agreements. Specify that in case of divorce, Travis would not pay spousal support payments. Moreover, each would keep their separate property, of which Travis has much and Daryl has little. Okay, so right at the beginning, we got one party with a lot, one party with a little. So we have an agreement at the beginning that seems to be a little bit unconscionable at beginning, at the onset. So let's read further. Travis insists Daryl sign the agreement before the wedding. They marry and subsequently divorce. Daryl challenges the agreement. The court will likely find the agreement is. So for question 10, let's look at the answer choices, because we have some unconscionability here where one has a lot, one has a little bit, but we still have the agreement being signed and it seems like everybody kind of knows what's going on. So let's read through the answer choices, because now we're going to determine if this is enforceable or unenforceable. So we have enforceable. So the first three answer choices see unenforceable, and the last one says enforceable. So let's start with A. It's unenforceable because Travis placed Daryl under duress by making him sign a condition of their marriage. No, I don't see any duress here. I'm just, let's just remove that, because there's really no duress. If you're gonna get married, you sign a prenup. If you don't, we don't. I don't really see an argument for duress. And plus, remember, there are elements and some factors for duress that we didn't really go into. So I would just remove A, because number one, we really didn't learn the rule for duress, and two, I really don't see duress here. I see a hard choice. If you want to marry me, sign the agreement, but I don't really see duress or a legally recognizable reason for duress. What about B? Unenforceable because the disparity of terms is unconscionable. Well, the terms here just say he wouldn't pay spousal support and they would keep their separate property. So, you keep what you got, I keep what I got. It doesn't really seem like there's this disparity. So it looks a little bit unconscionable, but I don't know. I'll keep that in abeyance, but I don't think that's the best answer. It sounds all right, but I don't know. I don't like it as much as another answer choice here. So let's hold it in abeyance. C, unenforceable because Daryl had no assistance of counsel. We don't. That's not one of the reasons why we would not enforce this prenuptial agreement. Unconscionability is definitely one would be, but just because you didn't have assistance of counsel is not one of the reasons. And D, enforce the contract unless Daryl can show a lack of informed consent or voluntariness. Now, this, I think, is probably the best answer choice. But I could see B. But I think the best answer choice is that this would be enforceable, unless Daryl could show either a lack of intent or informed consent or voluntariness. Now let me see what the professor puts as the answer choice. And yeah, and majority of students got this one right. It is D. And it seems very clear. And plus, since we didn't really pull out the rules for unconscionability, disparity in terms doesn't really lead to unconscionability. There's more to it than just that. So right now, for answer choice 10, D is the answer. Any questions? Let me go to the side chat to say there are no questions. Okay, so answer for question 10, answer choice is D. Question 11. Oh, you know what? Before we even move on, let's go to the rule document just to see. For instance, here is in re Schenck. Now this is for prenuptial agreements. Voluntary, unconscionability, and financial disclosure. So we did have voluntarily, we had an issue with unconscionability. But again, the rules we didn't have rules to test whether something was unconscionable or not. And we did have financial disclosure because the test, the question of whether both parties knew what each other had didn't really come up in the question. So yeah, I can see how people can make an argument for B, but I think D is just the best answer choice because it's going to be held enforceable unless. Moving on to question 11. All right. Daryl and Devin marry on vacation in Mexico after 10 years of being a couple. They return home to Kent, which recognizes common law marriages. One day, Daryl realizes that the couple never received the marriage license. Oh no, no marriage license. And thus, the marriage is not recognized by the state. So hold on. So you're not recognizing my marriage because I didn't get a marriage license? Kent law makes it illegal to get married without a marriage license. And any marriage solemnized without a marriage license is void. Boom. So they got married, and they didn't get a marriage. So now the state says, without a license, your marriage is void. So now we're starting to start thinking about, is this an impediment to marriage? Can the state do this? The couple sues the state, claiming that the statute violates their rights. What is the likely outcome of their challenges? Now, this is a question that, again, me and the professor, when we went over this question, we had a couple of issues with. We both got different answers. Now, let's go through the answer choices, and I'll tell you which answer choice the professor chose and which answer choice that I chose, and we'll explain that no one got this question wrong. Everyone got credit for this question. So, let's go with answer choice A. The court will likely rule that because they never received the marriage license, the couple was never married. That answer choice is incorrect because this seems to be a substantial bar to marriage. If we look at let's look at the rule document, and remember this rule from Loving, Virginia, and from Zablocki, where if the state passes a law that's a direct and substantial interference to get married, then the court would apply strict scrutiny, and we all know strict scrutiny is likely to fail. So here, if you can't get married without this marriage license, then that is a direct and substantial interference, and the court would apply strict scrutiny. So again, it seems like here, under Zablocki, this marriage license would receive strict scrutiny. Let's go back to the test. So here, answer choice A is that this answer choice A is unlikely to be the answer choice because the court would apply strict scrutiny. What about answer choice B? The court will likely rule that a license requirement is a direct substantial interference to getting married and therefore unconstitutional. Well, yes, that is exactly what we think. That makes sense. You can't get married unless you get this license, direct substantial interference, therefore unconstitutional. The majority of people picked this, and this, I believe, is a correct answer. But what about answer choice C? The court will rule that the license requirement did not significantly interfere with the decisions to enter into the marriage relationship and is constitutional. Again, that's kind of just the reverse of A. And then what about D? The court will rule that the marriage restrictions are reasonably related to the state's interest. Now, this is where myself and the professor differed. The professor says she was more likely to rule with D. I was more likely to insist A based on Zablocki. So we came to the agreement that we'll give N the fact that A and C were kind of superfluous to answer choice B and D. Everyone who made a choice with this answer, whatever answer you put, we gave you credit for. But here, the correct answer choice would actually be B. But it's just the answer choices to this question were bad. So no matter what answer choice you picked, but the fact that if you couldn't get married based on the license, then the court would apply strict scrutiny, and that's based on Zablocki. So we have chosen. So again, no matter what answer choice you picked for this question, you got it right. But B and D were the ones that me and the professor thought were the best answer choices. If there are any questions, you can type them into the side chat. I'll be answering. I'm still looking at them, so make sure we're all good there. All right. Question 12. Gary, age 16. Wanda, age 19. All right, so Gary's underage. Wanda is above 18. Get married in a state where marriage of minors under 18 is voidable. Okay, so that doesn't affect Wanda at all, but Gary has 2 years to go and ask the court to void this marriage because Gary is only 16. They move in together and live happily for 2 months. 3 months later, Wanda seeks to end the marriage. Okay, so they're happily married for 2 months. 3 months later, Wanda seeks to end it. So Gary's still under the age of 18, right? It hasn't been 2 years. We're talking about at most 5 months. She files an action claiming that the marriage is voidable because Gary is under the age of legal consent. Hold on. She can't do that because she's over age. Only Gary can go and ask the court to void the marriage. Wanda consults an attorney. their attorney should say. So we should all be in harmony with this, is that she's, out of luck. She has to kind of just seek a regular divorce. She can't seek it to be void because she was of the age of majority. Gary could actually seek to have the marriage voidable based on age. She cannot. Let's evaluate the answer choices. A, Wanda can file a motion to have the marriage declared void. No. Boom. We know that A is wrong. B, Wanda cannot file a motion to have the marriage declared void because only way to end a legal marriage is divorce. That's just wrong on the law. Marriages can be void and marriages can be voidable. So B is wrong, just based on the law. C, Wanda can file a motion to have a marriage declared void. Well, we know for a fact Wanda can't file the motion because Wanda was above age when they got married. Because one of the parties is under legal consent. No, Wanda can't do that because she would have to be the one underage and to have filed the motion, and she got married to him while he was 19. So that is not a choice Wanda has. So A, B, and C are just wrong. Answer choice D, which, let me see how many people picked this for number 12. The high majority, we're talking about like in the 90s again. Wanda cannot file a motion to have the marriage declared void. Yes, because she was of age. She was of the age of consent to a marriage or to the marriage. But D is the correct choice. She can't file a motion to void the marriage because she was of legal age. So D is the correct answer from question 12. Let's move now to question number 13. Donald and Samantha have lived together for 3 years. They have told everyone that they were married, but no ceremony has ever been performed. So we got cohabitation, we got holding themselves out to be married, and they've never been in a ceremony. They have no children, but Donald has many nieces and nephews that often spend time with them and calls Samantha auntie. Okay, so Samantha has a huge argument with Donald and wants to move out of the house they own jointly. Friends advise her to divorce him. In a typical state that recognizes common law marriages, which answer is correct? So again, this is answer choice number 13. And we're evaluating answer choices. So, question 13, let's start with A. Donald and Samantha can sign an agreement for a common law divorce. Again, there's nothing in our notes about a common law divorce, so that answer choice should have just been struck as wrong. We've heard nothing about common law divorce. B, Donald and Samantha have not cohabitated for 5 years, so there is no valid common law marriage. Therefore, there can be no divorce. Again, this is trying to test your knowledge of common law marriages. Remember, there was really no set time frame because remember there was one case where you can be cohabitating for 3 days and submit common law marriage. So this 5-year requirement is something that the question made up. Let's just remove that off the paper. So A and B are just wrong. C, Donald and Samantha have no children, so there is no valid common law marriage. Well, having children is not a requirement for common law marriage. So now, at this point, I would just circle D and move on, right? Because A, B, and C are just so bad. But let's look at D just for kicks. Samantha must file for divorce in the same manner as if she and Donald had been married ceremonially. Yes, because if you're common law married, then if you're going to get divorced, you have to go through the same procedures. So, in this choice, D is the answer choice. So, the answer choice for question number 13 is D. So now we're moving on to question 14, which again, a very high majority of people got this one correct. So, question 14, which of the following is not a required element when establishing a common law marriage? Intent, duration of the relationship, capacity to get married, or outward behavior. So, we've been talking about common law marriages for like the past hour. So, we know you have to have intent to be married. Check. Okay, that is a requirement. What about the capacity to get married? Yes. Outward behavior, you have to hold yourselves out to be married. but the duration of the relationship. Again, we just had the question where it said 5 years. We said no, that's BS. It could be 3 days. So there is no really duration requirement element. So the best answer choice here is B, and this is just something you'd have to know. But since most people have the notes in front of them, B is the correct answer choice. So the answer choice for this question 14, which the high majority of people got, is B. We're in the home stretch. Don't forget, Sundays at 2 o'clock. We're going to continuously be doing this. Hold on, let me move this down a little bit. So just as another reminder, I feel like one of those commercials. You know how the commercials come on right in the middle of the thing and just continuously remind you. So this is a commercial. Next week, 2 o'clock, here again in the same room, we're going to be doing evidence, and we're going to be doing constructs. We're going to be going over the constructs' actual rules, because it seems to be a little confusion with some students about what the actual rules are for constructs. So we're going to be going over that. We're also going to be going over character evidence and some of the things for outlining for evidence. So again, that's going to be next week at 2. If you don't want to come into the class, we're going to be live streaming it just like we are today. I'm actually going to be opening up a video conferencing room, so if you guys want to actually join via video conference, you can, and we'll be going on. So moving on to our next question. Question number 15. Before marriage, Suzanne and Louis signed a prenuptial agreement where they agree that they will keep their finances separate. Any money acquired before the marriage will remain separate. Okay. If their marriage should end, neither will seek support from the other. After 25 years of marriage, which is a pretty long time, Louis seeks a divorce. Suzanne retired early because of health problems. Now she has a pension of $40,000 a year as her sole income. Louis continues to work as a CEO, earning $5 million a year. If Louis seeks to contest the prenup in court, the judge will most likely. Okay, so why would Louis? And this is the interesting part about this question. Why would Louis object to the prenup? Because it would be a good thing for him, right? Any money acquired before the marriage will remain separate. If the marriage should end, neither will seek support from the other. Right? Yeah, so this would be great for Louis. Suzanne would be the one screwed because she only got a $40,000 pension, while Louis has got is earning $5 million a year. But he's the one seeking to contest it. So, which one would it be? Let's look at answer choice A. The court will likely enforce the agreement. Well, would they? It's funny because this is one of those questions where I liked it. I didn't like it as the best answer, but I did like it as an answer because it did seem like, for instance, this didn't seem to be unconscionable to me. Because at the time when the agreement was signed, this just didn't seem unconscionable. Let's look at the rules for unconscionability just to be clear. Oops. Where is the pointer? Here we go. See, for unconscionability, for something to be unconscionable, the agreement was unconscionable when it was executed. So that means at the beginning, right? When it was signed. And it doesn't seem like this one was. It seems like it was good, but, after 25 years of marriage, then one person, gained all this wealth, while the other person didn't. So it seems like it was good at the time it was executed. It wasn't unconscionable then. So that's why I kind of liked A. But I lost that argument. No. A is the correct answer. What I'm talking about. Yeah, I liked A. So A is the right answer. You would enforce the agreement because since at the time it was executed, it was not unconscionable. It was a fair agreement, and it became this. It had this disproportionate impact later. Then yeah, you would still enforce this agreement, no matter how different their amounts are later. So A is the answer. What about, let's look at B, refuse to enforce the agreement because it is unconscionable, but again, It's not unconscionable because at the time they signed it, it was good. Remember, unconscionability is understanding how the agreement was at the time it was executed, which when, at the time this one was executed, it was good. C, refusal to enforce the agreement as to property, but not to spousal support. We really didn't learn this, so that this shouldn't have even been on your radar. And D, refuse to enforce the agreement because it violates public policy. Again, we have nothing in our notes to say anything about it violating public policy. Even though this is kind of crazy. You get this $40,000, $5 million difference. But again, if that had happened when the agreement was executed, then you have an argument for unconscionability. But since this happened 25 years later after the agreement was executed, you don't have that argument. So here the best answer is A. All right, final question. 16. So this is the bonus question for 3 points. A lot of people actually got this one right, which is good. Molly and Mark are married and have a son, Sam, who is 21. So we have Molly and Mark, and they have a son, Sam. So now one thing we know, Molly and Mark can't marry Sam, right? Because that's the son. That would be void. And the daughter, Sally. So Molly and Mark can't marry Sam or Sally, and neither Sam or Sally can't marry each other. And this is Sally, who is 16. So Molly, right, has a brother, Harry, and his wife, Heidi, so Molly's brother, Harry, and his wife, Heidi, have a son, Chuck, who is 23, and an adopted daughter, Carol, who is 18. So Molly and Harry also have a younger sister named Anne, who is 26. So we have a lot going on here. So we have Molly and Mark. They got 2 kids. Then Molly's brother, Harry, and his wife has a son and an adopted daughter. So, and then we have Molly and Harry also have a younger sister, Anne. So we got a lot going on. So the way I generally like to do these type of questions is just write it all out. Who's going where, and then make a nice little tree to kind of determine like where's everything going. Who is marrying who, what's going on. So with this is really playing on our understanding of incest, it seems like. So let's talk about New York incest. In New York, you can't marry your parents. Uncles can't marry their nieces and nephews, right? First cousins are okay. That, you can't marry your parents, that type of thing. So let's look at the answer choices. All states prohibit Chuck from marrying Sally. So who is Chuck? Chuck is the son. So Harry and his wife Heidi have a son, Chuck. So Harry and Heidi, their son Chuck, is trying to marry Sally, who is 16, and they are cousins, right? So all states prohibit these cousins from marrying, even if Molly and Mark give their consent. Well, them being cousins, if they're cousins, could they marry in the state of New York? Yes. So they are good. So A is wrong, right? Mark and Molly have gotten divorced, which is statement is true. So this one is wrong. All states don't prohibit Chuck from marrying Sally because they are cousins. And they could get married here in New York, for instance. What about the majority of states prohibit permits Chuck to marry Sally once she reaches the age of 18? Well, that would make sense because they are cousins. And if she reaches the age of 18, it seems like that one is a good answer. They could marry. Yes, so B looks like a great answer. Let's look at C. All states permit Chuck to marry Carol. So Chuck and Carol are adopted brother and sister. So remember that case in which the father wanted to marry his adopted daughter and the state said no because when you're adopted it more or less brings you into that blood relation too. So they would actually be treated like if they were actual brother and sister by blood. So yes, not all states would not allow them to marry. And what about D? All states prohibit Sam from marrying Molly. Okay, so Sam is the son of Molly's son. Okay, yes. I'm sorry, from Sam from Molly marry, or Sally. Sally, his sister, yes. But a majority of states would permit Sam, okay, who is to marry Anne. Now, who is Anne again? Anne is, where's this at? Sam can marry Anne. Anne is youngest sister. Well, Anne is his aunt, right? Anne is his aunt. Because Anne is the sister. Molly and Harry also have a younger sister, Anne. And Molly is Sam's mother. So Anne is actually his aunt, even though he's younger. So in New York, the fact that she's his aunt would not allow them to marry, because that would be incestuous in New York. So here the correct answer is B, because the majority of the states would allow these cousins to marry when she reaches the age of 18. And a high majority of students picked that answer. So, thanks again for watching this edition of Skills. I know we went a little longer than I expected. Right now it's about 3:18. But now you've understood the answer choices for each one of these. I have to type some of these up too, so people can get these in Word format. But I'm going to ask if anybody has any lingering questions about this exam. Speak now or forever stop typing on your keyboard, or hold your peace. All right, with that said, I am going to say thank you for watching, and I will see you next Sunday at 2 o'clock. We'll be going over evidence and constructs and start seeing if we can start preparing for the final exam. So, this is Nate for Skills, and I thank you again for watching, and we'll see you next time.